morning. Calling our next case, Farm Bureau versus Eagle. This is a 20-minute grant, and we have two amici with 5 minutes apiece. And we are starting with Ms. Morrisell.
May it please the court. I'm Elizabeth Morrisell from the Michigan Department of the Attorney General. I'm here on behalf of the Michigan Department of Environment, Great Lakes, and Energy. Next to me is co-counsel Jennifer Rosa, Michigan Solicitor General Ann Sherman, and then Rob Michaels and Katie Garvey from the Environmental Law and Policy Center on behalf of environmental amici. I'd like to reserve 5 minutes of time for rebuttal. Nearly 2 decades ago, the Michigan Farm Bureau challenged the department's CAFO-specific permitting regulations for being too stringent, and they lost. Today, those strict rules, along with the rest of the Part 21 wastewater discharge permitting rules and the Part 4 water quality standards, lay out detailed procedural and substantive requirements explaining how the department meets its statutory mandate under MCL 324.3106 to issue permits that assure compliance with state water quality standards. Now, industry picks bits and pieces of that regulatory framework that it thinks conflicts with new permit conditions to support an argument that the permit should have been promulgated as a rule instead. However, reading the APA as a whole, and not just the definition of rule in isolation, demonstrates that this general NPDES permit, like all pollution permits that the department issues under the NREPA, are licenses, and as such must be challenged in a contested case before they can be subject to judicial review. MCL 24.264 has no application to the case at the bar. This appeal presents an opportunity for a clean fix without widespread impact, as Justice Viviano just said, to put this case back on the rails. Vacate the incorrect reasoning of the Court of Appeals and let the proper challenge to this permit go forward in the contested case, as it should have in the first instance. The ALJ can issue his own findings of fact and conclusions of law, and then make the initial determination whether any of the challenges to—
Counsel, good morning and welcome. And you're doing an excellent job. I just want to focus on one key concern that I have here, which is ultimately that when you're dealing with a rule versus a license, people have the opportunity to come, they have the opportunity to explain, they can do a cost benefit, they have the opportunity to be heard. The concern that I have here is, under your argument, does that allow for folks the opportunity to be heard in the standard process that would normally be done?
That's a great question, Your Honor. And people have the right to be heard to challenge every single aspect of a permit in the contested case. Industry was given over 150 pages of briefing after the conclusion of a 2-week contested case, which occurred after the pre-filing of hundreds of pages of testimony, including hundreds of exhibits. In that contested case, industry made every single argument it's made before the Court of Claims and then some. Notably, in that contested case proceeding, all people who were interested in the permit were represented. The environmental groups, who right now are only amici, were active parties in that case, and they were able to also share their concerns about the permit, in particular that they thought that it was not sufficiently stringent. And so what's great about the contested case, as opposed to judicial review, is that an ALJ has flexibility to craft an appropriate remedy. In this particular case, again, which is not before the bar because it has been stayed as a result of the improper challenge, but in that contested case, the ALJ has flexibility to craft a remedy that will not have widespread implications. He can issue his own findings of fact and conclusions of law, and then he can craft new permit conditions, if necessary, to make sure water quality is
But doesn't a
safeguarded.
rule allow for an actual real hearing? People can come, they can testify, they can say what they feel, they can explain how it's going to affect them, they can explain how it's going to impact them.
Part of the procedural requirements that are laid out in the Part 21 permitting discharge rules include procedural safeguards about public notice and ensuring that there's public hearings so that in advance of putting a draft permit out for notice, people are aware of it, there is public comment, and the department receives comments. They received 2,400 comments about the permit at issue, responded to it, issued a final permit that incorporated some of those comments. Again, this is not in the record that has gone up to this court, but aspects of the final general permit reflect changes that had been suggested by industry.
Thank you, Counsel.
Is there any limit to how far the department can go in imposing new requirements in a general permit before we would consider it to be a rule?
There's always limits on what the department may do. The department, like any executive branch agency, is only able to act in accordance with the statutory directive that the legislature has given it. Under Part 31, which is the water resources.
It just seems a little bit anomalous here because the legislature has said you can't promulgate rules in this area, and so it seems certainly to the parties on the other side that you're essentially promulgating rules with these general permit requirements that have changed the state of play, the regulations in this area in ways that are significant. And so the question is, how far can you go on this line? What limiting principle is there?
Under the public trust doctrine and under the plain language of the NAREPA, the department shall issue permits that assure compliance with state water quality standards. The department does not have the authority to issue permits that are insufficiently protected.
But where do those state water quality standards come from? I mean, the department's imposing these requirements, but they don't come from state law.
The Part 4 water quality standards lay out all of the state water quality standards that were either promulgated as rules or can be calculated based on a formula that was promulgated by rule. Every single detail of this permit is envisioned by an existing regulatory framework, which notably was challenged by the Michigan Farm Bureau unsuccessfully over 2 decades ago. Another thing that's important to keep in mind here is that a permit there is no right to pollute. A permit is essentially permission to pollute a certain amount of pollution with conditions. Now, one of the things that has changed since the department first promulgated 2196, again, that's just part of the Part 21 rules. It's only a part of the regulatory framework, but it's the part specific to CAFOs. Since the department promulgated that, what's happened is there are now 3 times as many CAFOs as there used to be. They are larger and they produce more waste and more concentrated waste that they wish to dispose of in our water. The department, under its rules, has to ensure that those permits to pollute do not create a dangerous situation for the rest of the people of Michigan. And again, not before this court, but there is, well, this court can take judicial notice because it was flagged in the briefs, is that there are many waters in Michigan that are impaired for the type of pollutants that CAFOs emit, for E. coli and for nutrients. And there is no right to pollute, and there is certainly no right to pollute an already impaired waterway. The thing that's really important.
Let me just go back to my question, because there's a lot of, I mean, you just gave us a lot of information, but what's the limiting principle on how far you can go in a general permit to impose requirements? Can you do anything at all? Can you, I mean, I can't think of, this isn't my expertise, so I can't think of great hypotheticals on what you might do, but what's the limiting principle?
I could give you an example of what you can't do.
Okay.
So let's say there is a new pollutant. We're going to call it T-bar. There's no water quality standard for it. It's not referenced in any of the water quality standards, and it is produced through a process that had been unknown previously. Before the department can limit discharges of that unknown pollutant that we don't know how much is safe to be in our waters, they have to first establish a water quality standard for that pollutant. Otherwise, there is no standard, and it wouldn't make any sense.
So for example, here is the 30-foot berm has to be
35-foot
constructed?
vegetated buffer. And so that's a very complicated condition, and the industry has simplified it, but they've simplified it to the point that they apparently don't understand it, and they've confused everyone who they've tried to explain it to without any, without the larger context of the regulatory framework. So if we look
That's sort of aggressive, but okay.
It's aggressive, but the buffer requirement exists within a larger permit condition, and that larger permit condition says you have to control the amount of waste that you put on your fields so that it doesn't get off into the water. The rules that we're talking about already said land application that occurs in accordance with these rules can be authorized by a permit so long as it doesn't cause or contribute to water quality exceedances. And so the buffer requirement, it's not an individual requirement, it's related to a much bigger thing. So essentially, under the permit, CAFOs can choose to either test their soil for phosphorus rates, and if they test their soil, then they have to do a buffer and a setback unless they can demonstrate something alternative that's equally protective. In the alternative to testing for soil, they can use a new phosphorus, well, it's not a new, they can use a phosphorus assessment that existed in the 2015 permit, and that phosphorus assessment will drive certain decisions that they make about what to do on their fields. But again, putting this into perspective, we are not talking about applying a small amount of fertilizer so that your crops grow. We are talking about disposing of millions of gallons of liquid waste and millions of tons of solid waste. The perspective is it's more than 24 and a half Deepwater Horizon spills every year is the amount of liquid waste that they produce and dispose of pursuant to their permits. That is an incredibly large amount of waste, and it has to be disposed of safely so that it doesn't pollute our waterways.
Let me ask you a question on the APA. Would an agency that failed to comply with the APA requirements for promulgating a rule and providing notice be subject to a declaratory judgment action under MCL 24.264?
So if an agency failed to comply with the procedural requirements of the APA for rulemaking, would it have to ask a declaratory ruling? If it is a procedural application, there is some case law that suggests that you don't need to have the declaratory ruling in order to challenge the procedural application. But it's inapplicable to this case here because this case is not a rule.
No, I understand. That's what I'm trying to get at, and I guess you anticipated that. Why would this change simply because the agency decides to declare that its rule is a guidance document instead of a rule?
So this is not a guidance document. This is a permit, and the reason it's not a rule is for all of the reasons that it is a permit. It's simply something different. The standards that are contained within it are already established by rule. There's not a question of there being a procedural problem or there being new standards that are being announced through a permit. It is simply interpreting existing law. Many of the cases that have come before that talk about being an unpromulgated rule, they don't have the detailed regulatory framework that we're talking about today that the department operates under. In 2006, when the rulemaking authority was removed from the department, the legislature was aware of the extremely detailed permitting regulations and framework that the department had already promulgated its rules as well as its water quality standards. And so that's why it didn't act as an implicit repeal by implication of the department's mandate to issue permits that assure compliance with water quality standards, because the regulatory framework is very detailed and it's flexible so that a permit writer can craft individual conditions as necessary. This is another thing that's important to keep in mind. Issuing a permit is a quasi-judicial act. It is not a quasi-legislative act. It is about applying facts to the law.
Can I, and maybe this is similar to what Justice Zara was expressing, sort of coming up a bit from the details and the minutia of this particular permit and rules and that, but looking at the statutory procedure in general for being able, whether you can bring the declaratory judgment. If the contention is that what you are saying is a general permit condition is in fact a rule, and I understand all the reasons why you say that's not the case here, this isn't a rule, and not getting to that, why shouldn't somebody be able to bring a declaratory judgment to get that determination? And I guess part of that, so if I say, you say, I don't know, condition A, it's a permit condition, it's not a rule. Their contention is you can call it a permit condition, but here's all the reasons why we think it's a rule. We get to challenge that through a declaratory judgment action, and that gets determined separate from the contested hearing of you know, the intricacies or the you know, the benefit or whatever it may be about the actual condition, or what you call a condition, they call a rule. Or, and maybe part of that is does that determination of, is it a permit condition or is it a rule, does that get determined in a contested hearing? Is that your position, that all of that occurs there?
Everything can occur in the contested case proceeding. Every single argument that industry wants to put at this permit, they can put in front of it at the contested case hearing, and they did. They had 150 pages to brief, and they used their pages. They may take constitutional arguments are made before the contested case. The argument that this is a rule, the argument that this is invalid and exceeds the department's authority, the various reasons why it's arbitrary and capricious, the various reasons why it's unnecessary, every single thing that they could think about to challenge this permit, the various permit conditions, they put forward into the contested
So
case.
maybe that's, so they can, are they precluded from challenging, from saying, we think this is a rule, and therefore, under the statute, we get to bring a declaratory judgment to have that point determined?
Absolutely. They're precluded from challenging any aspect of a permit as a rule because it's a permit that's issued according to permitting regulations. And if you read the APA as a whole, you can see that there's separate chapters for licenses with contested case proceedings. They're distinct from rulemaking. And if you allow a challenge to a license to appear as a challenge to a rule under judicial review without the creation of a record, you do not get a full and fair analysis of that license. Again, when the state is sued in the Court of Claims, then you cannot have the environmental amici intervening to say what their rights are and what their concerns are. And so what's good about the contested case is that everyone's heard.
So the reason,
And
so
I'd like-
the, oh, I was going to say, for the reason for the contested case proceeding is to really flesh out the record and get a full record. Is that one of the reasons it's important?
The reason it's important because you get to flesh out the full record, and it's an opportunity for the agency to correct any mistakes if it may have done. And again, one of the things that is pending before the contested case is whether the permit did not go far enough and whether it should be stricter. And I think I'm at my 5 minutes and would like to reserve the rest of the time for
You have 3 minutes for rebuttal.
Thank you.
Mr. Michaels?
Good morning. May it please the court, Robert Michaels for the environmental amici. I want to thank you all very much for allowing us to participate this morning. Several of you asked about, well, what's the limiting principle here? And the limiting principle is clear. It's that because Eagle promulgated an entire set of rules, the Part 4 water quality standards, they had promulgated the Part 21 rules, they created an entire permitting regime. Those rules create the limits on what can be in a permit. And that includes Rule 2196, and those rules create the limits for what can be in a permit. And if a regulated party thinks that, hey, these permit terms go too far, they are not authorized by the rule, they're not consistent with the rule, they can argue that in the contested case. If the regulated party thinks, hey, you know what, I don't need a factual record, I can just show you right on the face of this permit, you went too far. Move for summary disposition in the contested case. Their rights are fully protected. And it's really key here to look at what the Part 21 rules say. And the real key provision here in Rule 2196 is that it is the requirement to create a certified nutrient management plan. And here's what the rule says. At a minimum, a CNMP shall include the best management practices and procedures necessary to implement applicable effluent limitations, including all of the following. On its face, that rule, which industry challenged and lost, allowed Eagle to issue permits that assure compliance with water quality standards within these boundaries. If you had, under the Court of Appeals ruling, however, any time Eagle wants to add a single condition to a permit that does not appear on the face of the rule, they have to promulgate a new rule. Well, that not only prevents Eagle from discharging its statutory responsibility to issue permits that shall that will assure compliance with water quality standards, it effectively invalidates the provision in Rule 2196 that was duly promulgated, that I just read. In the
I'm having
court.
a hard time separating in my mind a rule from a condition on a general license that is applied to everybody to every applicant.
So
How should I think of the distinction? What's the way to distinguish between those?
that's a great question, Your Honor, and I think if you look at the text and the structure of the
I'm following
APA.
Justice Bernstein's approach in trying to simplify something that's not very simple, but I'm going to try.
Right, no, I get it. And the answer is really simple. If a permit condition that is issued pursuant to a set of duly promulgated rules is a license, it cannot be a rule. If it exceeds the authorization in a rule, why then it's an invalid permit term. They can challenge it.
I get that you have the power to say, if you're not meeting all these standards, and I don't even want to get into the technical description of those standards, then you're not going to get a license. What I don't get is you get to impose all these conditions. I mean, what if the Eagle said, you only get a license if you dispose of this waste on the moon?
Well, then it's an invalid permit condition. I think if you look, there's nothing in the APA.
But it can only be challenged in an individual case? It can't be
No,
challenged as a
if
general permitting requirement
They-
by every applicant?
They absolutely could challenge it. They could do exactly what they did here. They could, let's say, here's a better example that would, let's say.
I told you my hypothetical.
Yeah, no, sorry. Let's say the Eagle issued a permit that said, you know what, you have to treat your waste, you have to treat it to municipal wastewater treatment standards. And we're saying that new condition is somehow authorized by these rules. Well, we happen to think that would be good policy, but it's really not authorized by these rules. They could go into a contested case, they'd say, hey, look, you know what, we don't even need a factual record. Eagle went too far, it's an unauthorized permit condition. They'd win in the contested case, and then Eagle would have an issue on its hands. They'd have to say, look, if we want treatment, we're going to have to promulgate a new rule. But the point that we're
And they
really
might have to pay for it.
trying to
Like
make.
the public does otherwise, right?
Well,
For
I mean,
human waste.
there'd be a host of problems they'd have to deal with, but the point is that under the APA, there is no suggestion that something can simultaneously be a license and a rule. The definition of rule does not include license. License is separately defined. They are in separate chapters of the APA. In any permit term, any general permit term, you could, if you just read in pure isolation that abstract definition of rule, it would probably, arguably satisfy it presuming you established it was generally applicable. Eagle, and this is key, Eagle's current general permit that these operations are operating under is from 2015. The state admits it is failing to assure compliance with water quality standards as required by NEREPA. That would be locked in place permanently because Eagle cannot promulgate new rules under Part 31. But when the legislature took Eagle's permitting power away, or rulemaking power away, it specifically said that the existing rules remain in place. That includes the Part 4 water quality standards, it includes the Part 21 rules, and that includes the rule I read to you, 2196. At a minimum, they clearly, this duly promulgated rule that was challenged and they lost the challenge, allows Eagle to update these permits within the bounds of the rules in order to issue permits that will assure compliance with water quality standards. That is a completely
Thank you.
harmonious
Yeah, thank you. Your time is up.
arrangement.
Appreciate
Oh,
it.
thank you very much.
Mr. Larson?
Well, good morning, Your Honors, and may it please the Court. Zach Larson on behalf of Farm Appellees, which includes over 100 family farms and several associations that collectively represent the livestock farming industry in Michigan. This Court has consistently stressed that an administrative agency may not simply call a rule something else and thereby avoid the APA. Yet that is exactly what Eagle did here. And that is the key issue today, whether an agency must follow the APA's procedures, which the legislature adopted to ensure that none of the essential functions of lawmaking under our democratic system are lost when laws are written by unelected bureaucrats rather than by elected representatives. Here, because EGLE essentially rewrote an existing rule in its 2020 CAFO general permit, and in doing so set new mandatory standards for an entire well-defined class of livestock farms, it created rules. And those rules needed to be promulgated before they could be given the full coercive force of $25,000 per day penalties for their violation. The answers to this court's other questions in its May order flow easily from that conclusion. First of all, because the agency's standards are rules, Section 64 gave farm appellees the right to challenge the validity of those rules in a declaratory judgment action that is designed to answer that threshold legal question promptly and efficiently. That did not require courts to wade into complex factual concerns regarding the wisdom or the justification for those standards. It simply asked a court to decide whether they complied with the procedural requirements of the APA. Second, nothing under Part 31 of NAREPA grants EGLE the exclusive jurisdiction to determine its own compliance with the APA, or to decide the validity of a rule, which is what Section 64 allows courts to decide.
Counsel, I just want to, I know we're debating sort of the declaratory judgment pathway and the contested case pathway, which you're pursuing both, I know. Why, speaking to opposing counsel's point that you need a full record to sort of make that decision, your position is declaratory judgment, we don't really need a full record. Why not? This is pretty complicated stuff. Why wouldn't we need a more full record?
Because the question for procedural validity, Justice Welch, is the question of whether or not the APA was complied with in its procedural terms. And that's our count one in the complaint. That's what's in front of the court today. So procedural validity goes to the question of just, did you have notice and comment consistent with the APA? Did you have a cost-benefit analysis? Did you submit this to the Joint Committee on Administrative Rules? If you meet the definition of rule, which is just those three prongs, and then the question of whether or not it fits within a particular exception, then procedural validity is a really easy question to answer.
But don't you have to have a factual record to determine whether or not it's a rule that needed to be promulgated under that, or whether or not it's a valid permit condition?
Not at all, Justice Kavanaugh. You don't need a factual record to determine whether it's a rule, because rule comes down to those three prongs. It starts with whether it is a policy statement, a regulation, standard, instruction, and then it's of general applicability, and then it implements or applies the law enforced by the agency. So if you meet those three conditions and you don't fall within one of the 20-plus exceptions.
Okay, and so that's where I want to stop you, because say I agree with you that you can use the declaratory judgment, statutory declaratory judgment vehicle to say, this is actually a rule. It's not a permit condition. That's the basis of our challenge, and maybe, and I think it seems like the nature of a general permit, which my understanding is the issuance of general permits as opposed to specific by specific is actually a benefit to the regulated community, right? I mean, of not having to go and seek individual permits, but I may be wrong about that, and you may have thoughts about that. But so maybe I agree with you that it's generally applicable. Tell me why, though, it doesn't fall within the exception of 24.207J as a decision by the agency to exercise or not exercise a permissive statutory power.
So, first of all, just a real quick comment on your question or your point about there being a benefit to the regulated community. It's actually, if you look at even the authority that was cited by EGLE in this, and you actually go read the law review article that they discussed, it's actually a benefit not just to the regulated community, but to the agency for its own efficiency.
So it benefits everybody to have these sort of generally applicable things. It still has to be a rule, though.
It's sort of beside the point as to whether or not it's a rule. It's more just a practical question, and it goes to the question of the legislature striking the right balance between the definition of the rule and the exceptions to the rule, which this court has said in AFSCME is really a policy decision for the legislature to make between the workability concerns and the democratic policy objectives of the APA in pursuing rulemaking. But to your point, in terms of the discretionary or permissive power exception under that subsection, what this court said in the AFSCME case, which was about a standard form contract, was that the decision to use the standard form contract may have been discretionary, but then actually setting the substantive content of those particular standards, that is rulemaking, that is quasi-legislative, because that gets to the heart of the distinction that Justice Viviano was trying to get to in terms of, what is, let's keep this simple, what is the distinction that we're talking about here? What's the limiting principle? It goes to the question of whether an agency is setting broad policy, in which case it's acting in a quasi-legislative function and is therefore, is supposed to go through the rulemaking process, or if it's engaging in individual case-by-case determination. We have several pages in our brief talking about this from U.S. Supreme Court cases, from cases in other states that are applying a similar APA to our APA, since our APA is based off of a model APA. But that's the fundamental distinction, is it quasi-legislative or is it quasi-judicial? And once you're getting to writing the content of the standards themselves, and those standards are binding upon the entire regulated community, that's lawmaking. It's effectively lawmaking.
So any condition within the general permit?
It's not
All
any
of
condition.
those standards have to be formally promulgated through the rulemaking process?
It's those that do not currently exist in law elsewhere. So Eagle is right that at one point, what it did was it took the existing standards out there in the federal rules, out there in the state rules, and incorporated them into the permit. It did that with the 2005 permit, for the 2010 permit, and pretty much for the 2015 permit. If you look at the attachments to their brief, those permits were all about the same length. They were 33 to 35 pages. What happened in 2020 was that ballooned to 44 pages in length, adding effectively 10 pages of new standards that, with all due respect to sister counsel here, are not anywhere in law, and in fact conflict in large part with, as the Court of Appeals found, with Rule 2196. They went through and they kind of said, case by case, look, there are things here where previously, you could land apply manure in the wintertime. Now you can't, because Eagle has put a new condition in there, even though Rule 2196 contemplates that you can. It said, hey, there are these other standards, like annual monitoring is in Rule 2196. Eagle has said, no, we want it quarterly. We want a report every 3 months rather than once a year. So it's changed these substantive standards that already exist in a rule, and when it's done that, it's effectively lawmaking. And if it had, if it were able to go through the rulemaking process in the first place, it can certainly do so again. But the point is, unless it falls, Justice Kavanaugh, within one of those particular exemptions, it is not exempt. And that is the analysis. There's no dichotomy between license and rule. If you look at the APA, yes, there's a different definition for license, but what that actually proves is that the legislature, if it wanted to exempt licenses or portions of licenses, very well could have done so. It has over 20 different exemptions expressly under Section 207. A lot of those are broad categories. Some of them are very specific actions. They have attorney general opinions. They have contested case decisions and orders. Many of these are actually actions which very clearly are not promulgated rules, and therefore kind of just prove the point that rule is not limited to the idea of a promulgated rule. As this court has said in Detroit-based coalition, in AFSCME, as the Michigan Court of Appeals has said in the Delta County case. So since it doesn't fall within a particular exemption, and it is within the broad definition, the new standards are in fact rules. The main point of dispute on this has been over the question of general applicability, but as I already spoke to, this is not a case-by-case determination. They're not going farm by farm saying, what are the standards that we're going to set here? They're setting it for the entire class of CAFOs. And if you look at Rule 2191, which is the decision by Eagle whether to use a general permit, they have to make a decision when they implement a general permit that, in fact, it addresses this broad category. They have to say that categorically, we can, a certain category of discharges are appropriately and adequately controlled buy a general permit, and then they have to, as part of that, make 4 specific determinations that involves the same or substantially similar types of operations, that involves the same type of wastes, that it involves the same types of effluent limits, and it involves the same type of monitorings. That means they've drawn lines around this class of cases that they are then writing laws for. And because of that, it has to go through the rulemaking process. Once you answer that question of whether or not it's a rule, then Section 64 and its application is pretty obvious. Section 64 says that it applies to rules, and because it says it applies to rules and there's no separate definition anywhere else in the APA, there's no modification of the word rule in Section 64, then the definition that is applied in Section 7 obviously applies in Section 64. The question of exclusivity is also a simple question, because exclusivity, and we provided analysis on this from Justice Zara and his time at the Court of Appeals, as well as from a more recent Court of Appeals decision from the Sliss case. If you're going to have a carve-out and say, well, the Court of Claims has jurisdiction except where exclusive jurisdiction is granted elsewhere, obviously that exclusive jurisdiction has to be a subset or has to be the same type of jurisdiction that's granted to the Court of Claims. So since the Court of Claims says jurisdiction to determine the validity of a rule, then the type of jurisdiction you're looking for in the enabling statute from the agency is going to be jurisdiction to determine the validity of a rule. There's no such jurisdiction in Part 31. There's nothing in the provisions that the Eagle has pointed to that demonstrate that type of jurisdiction. And even if it did, there's nothing that says that it is, in fact, exclusively within Eagle's jurisdiction.
You're doing an outstanding job. But the question that I have as we get into the concept of rule and the ability to be able to come to discuss it, to have your voice heard, what are the real-life implications of this on farmers?
Well, I appreciate that, Justice Bernstein. There are very significant real-life implications here for farmers. When it comes to sort of the procedural concerns that you raised, the biggest differences between Eagle going through licensing and Eagle going through rulemaking is that there are more robust procedures. There's more robust, there's cost-benefit analysis. To Justice Welch's point about creating a record, the record's probably actually more robust through rulemaking if they have to go through rulemaking, because there would be cost-benefit analysis. There would be an opportunity for the legislature to comment and review the rules. There's an opportunity for the Environmental Rules Committee to vet it. So there are all sorts of steps along the way that provide that kind of benefit to farmers to have their voices heard. There's also then, from the procedural standpoint, there is, in terms of Section 64 being available, it's an access to justice issue. It's a question of being able to promptly and efficiently get a legal determination about whether or not the agency's used the right process. And then the other real-world consequence here is just that fear of enforcement. That $25,000 per day of violation, there's not a lot of laws written by the legislature that have that same kind of consequence. And so when Eagle is then writing substantive standards that carry that weight practically for farmers who are small businesses as defined by the APA, as defined under Chapter 2 of the APA, that's a big deal. It's a very big deal to make sure that it's properly vetted, because going through the right procedure, it's not just about having the process, it's about getting to the right result by having the right process.
But can the ALJ do a lot of that? I mean, can't they do exactly what you're talking about in the contested case hearing?
The ALJ will not have legislative oversight. The ALJ will not do cost-benefit analysis.
I understand, but they can still talk about whether there was they exceeded potentially rulemaking or non-rulemaking authority, correct?
Right, but the question there is, to Justice Welch, in terms of the access to justice points, it's a question of getting in front of somebody who is not ultimately responsive to the agency, as the ALJ is under Part 13, ultimately responsive to the director. But it's a question of getting to an objective judicial determination.
But can you do a motion for summary in a contested case proceeding?
You can, though honestly, in my personal experience, proceedings move very slowly. And so even in that, it's not like noticing it up in a circuit court and getting there in a couple of weeks.
So,
You know, you're-
depending on our court, yes, of course,
Yeah.
I understand. But certainly, you would agree that as far as an objective outside view, those final contested case results can land.
They're ultimately, yes, they can ultimately go in front of a court. I do want to address really quickly a couple of points that have been made. One is there have been some concern raised that, oh, if you agree with us, then any permit term is potentially challengeable. No, again, it goes to the question of whether or not it's quasi-legislative, and obviously that's going to be limited to your general permit terms that are acting upon a class of circumstances.
What about, we heard from opposing counsel a couple times about a case in the past that your clients lost, that you're here basically trying to relitigate the issues that you lost or that you're somehow precluded from the arguments you're making today. Any response to that?
Absolutely not. The substance of the permit in 2005, again, is very different from the substance of the permit in 2020. That additional 9 pages adds an awful lot, and that is what we're litigating, is those additional and new permit conditions.
Did you litigate that through a contested hearing or through a declaratory action?
So ultimately, we're in both places right now, but the reason
Now,
why...
but back then?
Back then, I believe that was, that was originally through a declaratory judgment action, yes. Declaratory judgment action was brought. It made its way up through the appellate courts, but it's not, ultimately, this same type of issue did not come up. In terms of the question, there was an assertion at one point that there really are no new standards, that essentially Eagle is just taking, existing standards that exist elsewhere in law and putting them in there. Again, that's simply not accurate. Rule 2196, as we've mentioned, conflicts with the existing general permit. Actually, one quick point to Justice Welch's question on what couldn't the ALJ do. I'll tell you one thing that they can't do. They cannot decide the constitutional questions. So you have to go in front of an ALJ, even if you have objections on a constitutional basis, they won't answer them. And so you can't get those constitutional questions decided until you can get to the point of your appeal to an actual judicial decision maker. I'll be honest, I have no idea where I'm at time.
You have about 2 minutes left.
Okay. So the court has also raised this question of subject matter jurisdiction. And the issue in terms of subject matter jurisdiction, does the court have to address the question of rules? Yes, we think that the Court of Appeals was right to determine this question. The reason the court was right to determine this question was because subject matter jurisdiction is a court's authority to hear a class of cases, but also to determine whether an individual case falls within that class. And so here, when it's looking at the question of, I have jurisdiction to determine the validity of a rule, it has to also then determine this is one such a case. So we think it's a subject matter jurisdiction question, and the Court of Appeals got that right in addressing that. And that ultimately, if the court agrees with us on that and agrees with us on these other questions, that leaves our cross-application for leave to appeal. And it brings us to then that question, which I understand is not in front of the court. I'm not planning to argue today. But I think that ultimately what we're asking for, if the court agrees with us on those questions, is, I think cross-application demonstrates that exhaustion requirement was not really a requirement there, and that ultimately the court could determine the procedural validity issue on the cross-application. So effectively reverse on that one exhaustion requirement and determine that we're entitled to summary judgment on count 1, because that was something that we asked in front of the trial court, was under MCR 2.116I2, we asked for judgment in our favor in response to the jurisdictional question. Really quickly, there was a point made about buffer strips. Buffer strips are effectively going to be 35 feet wide, multiple acres for most farms, taking what would be productive cropland and instead making it just grass. Proving the point that the agency has in fact changed the law on this, the federal rules actually provide an either or. They say that you can either go, take a 35-foot buffer strip on a given field, or simply do a 100-foot setback, which means that you're not land applying manure for a space of 100 feet from the edge of the field or from a water, et cetera. Eagle has now made it a both and they testified in the administrative hearing that that was effectively their intent all along, was to make it a both and. Sounds like I'm out of time, but if you have any further questions, I'm happy to answer them.
Thank you very much.
All right, thank you.
Good morning, and may it please the court. I'm Patrick Moran, appearing on behalf of AMICI, National Federation of Independent Business Small Business Legal Center, and the Michigan Chamber of Commerce. The agency had no authority to promulgate a rule that changes the way that farmers do business. So instead, it changed the conditions on a permit to accomplish those same goals. But permits are not exempt from the APA's definition of a rule. If something fits that definition, it has to go through rulemaking, even if it's called a permit. And the APA process is not a mere formality. It includes notice, a hearing, and a regulatory impact statement which provide information and give the public a say in the process. The agency's failure to follow the APA process harms small businesses. Nearly all farms in Michigan are small businesses, and over 90% of them are family-owned. These small businesses are unfairly captured in the regulatory regime. And it's not just farms. Other businesses, such as distributors, grocery stores, restaurants, and ultimately the consumer will be affected by this. The cleanliness of Michigan's...
Can you answer for me why sub J of 207 doesn't apply, why this isn't a decision by the agency to exercise or not exercise a permissive statutory power, when I believe they cite 2189 that incorporates the federal standard of 40 CFR 122.44. Why is what they are doing not, maybe it's generally applicable, and that setting aside whether or not that can be challenged only in a contested hearing or can be both declaratory judgment and a contested hearing. Why is this not a decision that's not a rule because it fits the meaning of 207J?
Well, as the agency says in its brief, it admits actually that the permissive statutory power that's being exercised here is rulemaking. So that presents, I think, a problem. I don't think that those two things go along. The APA process is, and again, it's not just a formality. It gives the public an opportunity to say their piece. And to Justice Bernstein's earlier point, it goes beyond what a contested case proceeding can provide, because regular people are able to get up there and to offer their perspective, and also to offer to contest all of the evidence that the agency has to offer.
That's important, isn't it, for people to be able to participate in this since it affects them directly?
Yes, absolutely. I completely agree. And to give that point, there was supposed to be a regulatory impact statement that outlines basically the impact that this would have had on all industries in Michigan. But that didn't happen. And so we're dealing with an incomplete record at this point. And this affects farms and small businesses in various ways. To start, 81% of the milk cows in Michigan are on farms with 200 or more cows. So that's within the regulatory window. Excuse me, I meant to say milk cows with that. In addition, a conservative estimate places calves and cattle 60% within the regulatory window, and a more broad estimate could be up to 3/4. So this is a large percentage of the state's milk and meat supply. So this is going to have a downstream effect. It's going to affect meat prices, milk prices. It'll affect grocery stores. It'll affect restaurants. And it also affects farmers who aren't just being regulated here. If a farmer has to switch to synthetic fertilizer instead of manure, they may have to spend $10,000 to $12,000 additionally per year. And not to mention the $25,000 per day per violation fine if a farmer is found to be in violation of this. We can't imagine that cost is going to occur in a bubble. That will be passed on to consumers as well. And another unintended consequence, perhaps, in Fremont, a biodigester, which is green energy, is going to have to close. So this is unintentionally affecting green energy as well. And I think that if we had a regulatory impact statement, that would alleviate at least some of these concerns, because the agency would have done that, but they didn't do that.
What role can farmers' voices play if it's a rule? Specifically, what would they be able to do that they can't do if it's not?
I think that really goes to the public hearing. I think that's the prime time for farmers to get up there and to make their voices heard. In a contested case proceeding, you're not seeing just regular people going up and getting to have their voices heard. So I think it's important that farmers are able to bring their practical experience to the forefront. And that's what the APA process offers us ultimately. So I see that I'm out of time here. I just want to leave us on the note that agencies need to be accountable to the public and that businesses deserve the APA process. Thank you.
Thank you.
The real-life implication of this case, Your Honor, is that the people of the state of Michigan who are entitled to clean water would not have a voice if industry had its way. They would make arguments without data, without being able to have the people present their voice as they did in the contested case proceeding, and they would succeed on a procedural challenge that doesn't make any sense if you read the entire regulations.
But why is a public hearing so problematic?
Public hearing is not problematic. The department held multiple public meetings, public hearings in accordance with its own rules before it issued the permit. The important thing to keep in mind here is that a regulatory framework does not contain plastic injection molds for all possible conceivable future permit conditions. It contains a framework. That framework includes 21337D and the incorporation of 40 CFR 122.44D sub 1, both of which include mandates that the department include more stringent permit conditions when necessary. That's what happened here. Industry could have filed a motion for summary disposition in the contested case hearing, bringing these issues to the ALJ before the actual testimony started, and they elected not to because they knew that facts were important and they said as much on the record. Disputed facts are why 24.264 could not possibly apply here. As was shown based on the different things that were said back and forth, there are disputed facts here. The statement that you can only grow grass and is therefore a worthless use of a buffer makes no sense coming from an industry that raises dairy who eat grass that after it has been harvested and
But is this unique to farming? Because it just feels like in every other scenario, when you're talking about something that's going to really impact people on a direct basis and a direct nature, there's a process that goes through. They seem to be a part of it. People can take testimony. There are hearings. There's a whole litany of legislative issues that go into it. And I guess the question is, this is something that's very direct and personal to people. It affects their land, the use of their land, how they use their land, the way they use their land. And I guess my question is this really kind of a shortcut to not allow for folks to have that ability?
Absolutely not. The rules lay out all the restrictions and what must be in permits, and this permit simply sets additional restrictions on an industry that has grown in size and seeks to pollute more of Michigan's already polluted water with increased amounts of water pollution. I'd also like to briefly flag out that the DC Circuit Court of Appeals, which is essentially court of last guaranteed court for all federal agency disputes, has never once found an EPA general permit to be an unlawfully promulgated rule. Instead, what they found it to be was an interpretive rule when they denied a motion for summary disposition. That was an Army Corps permit, not an EPA permit. The trial court upheld those general permits as interpretive rules. Now, under the federal, again, we're not conceding that it is a rule, but the logic behind the federal EPA and the definition of an interpretive rule fits along with the 7J exemption in Michigan's APA. That's what the old Farm Bureau case said. So there's no federal precedent that's analogous that suggests that a general permit is an unlawfully promulgated rule.
Thank you all. The case will be submitted, and the court will stand at recess until 12:45.